appearances. First case I'd like to call out of order is Gregory Palermo. Good morning, sir.
Morning, sir.
Tell me your full name.
Gregory Palermo.
Sir, you entered a plea, bless you, before Judge O'Kane. It appears on August 23rd, 2021, about 3 months ago, and it alleges you violated probation during a search of your residence where they found a firearm along with ammunition and a knife, and a condition of your probation was that you not possess any of those. You're currently held on a no bond, and your attorney is going to be?
Whitney Bone, Your Honor. Good
Okay.
morning. Your Honor, I've spoken with the state. I don't believe that they object to the court setting a bond, and they would defer to the court as to amount. So if you'll let me speak as to that and persuade the court as to our position on bond.
Well, let me hear from the state first. Why on a violation of probation for obstructing a criminal investigation with somebody with a firearm and ammunition and weapons would you agree to a bond?
Mackenzie Allen for the state of Florida. Your Honor, it was portrayed to me that the underlying offense was pled to as a withhold and court costs along with some probation time. And we don't have extensive factual basis for what exactly happened during this violation of probation, which is why the state agreed to leave it at the court's discretion.
Would you rather obtain more extensive facts before agreeing to let somebody out who's on probation, who's in allegedly possession of a firearm, ammunition, and a weapon?
Typically, yes, Your Honor.
Why is this not typical?
Judge, can I be heard in terms of what I've explained to the state as well?
You can explain, but you have
Okay.
evidence to present, or are you just going to explain?
I have evidence I'll proffer, but also there's a lot about this case. Obviously, I've been Mr. Palermo's attorney for 2 years. I was his attorney at the time of the plea. I'm the attorney who negotiated the plea agreement in this case with Mark Wickstrom specifically. Judge O'Kane accepted the plea, and it's important for the court to understand it was done in a manner where obviously we were about to proceed to trial, and so it was in the best interest of both parties that he entered that plea. He's 52 years old, my client. He's about to be 53. Not only does he have no violent criminal history, his only criminal history at the time of his plea in this case on his criminal punishment code score sheet was a Willis and an expired tag. The agreement in the case followed him also having served 169 days in jail. He entered a plea as to 2 counts, an F3 and then an M1. He got time served on the M1. So all we're talking about here is a crime that he's on probation for with a maximum punishment of 5 years. At the time of his plea, his total sentencing points were 16.6. So I think that's extremely important for the court to understand in terms of the facts, or excuse me, the factors the court would weigh statutorily in terms of deciding what the appropriate terms of release would be or if release would be appropriate. There are not nature and circumstances of the offense here. As I explained to the state, the affidavit that's been provided to the court has not been submitted to a judge in terms of a full-blown affidavit of violation. Obviously, they're permitted to make on-view arrests, but the facts that are contained in that report are very conclusory in nature. There's nothing to substantiate how they reached the decision that he was in possession. In other words, as the court is aware, he doesn't live alone. I don't know if you're aware of that, but
I'm totally not aware of that.
he lives with his 85-year-old mother, okay? And
Is it his defense that it was her in possession of a Smith & Wesson?
it was her firearm,
Okay.
okay? And
He's charged with owning it. He's charged with possessing.
and I understand that, but there's nothing in the police report, and the weight of the evidence is one of the factors this court is also supposed to consider in terms of if you grant release, and if so, on what terms. I would say the weight of the evidence before the court right now is very minimal, and I am proffering to the court. It is his mother's firearm. But what the court is left with is somebody who, maximum punishment here, we're talking about an F3, and we're talking about someone who, if he was found to be have willfully and substantially violated his probation, let's say, he's not anti-murder, he's not a violent felony offender of special concern, so he's not ineligible for a bond. There's not going to be a requirement of a dangerousness finding, but beyond that, his sentencing total points with a technical violation, if he is found to even be willfully and substantially in violation, are going to be 22.6. And so that is nowhere close to even being in the range of scoring prison. He has lived locally for years. He has nowhere else to go. He lives with his mother. He was doing well on probation. He was going to his counseling. I spoke to his counselor yesterday. He was attending weekly individual counseling sessions, which was a condition of his probation. He was doing well with that. He was ordered to pay a significant amount of cost of investigation in this case based on the circumstances of the underlying case. It was payable to the sheriff's office. He's been making those payments. There's no allegations that he's absconded. There's never been any failures to appear in his past. He's not a risk of not showing up to court. He has stayed in regular contact with me even while he's been on probation, and routinely asked me questions in terms of making sure that he is doing his best to conform with the law. Previously, he had a drug problem. That's how we ended up, in short, that's how we ended up where we were dealing with the case in the first place. He is not alleged to be using. He's been doing his urinalysis. He's been doing well, Judge. His counselor says he's been doing well. He's not a risk of flight. He's not going anywhere. I would ask the court to weigh all of those factors. And that's, to be fair to the state, a lot of what I explained to the state too. I would ask the court to weigh all those factors in favor of giving him a bond in this case.
May I speak to your client? Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Please put your hand down. Ms. Bowen, object to anything you believe you don't want your client to answer. I won't be offended by it. Tell me your name.
Gregory Palermo.
Where were you born?
I was born in Queens, New York,
How long have you resided in the state of Florida?
since 1993.
And your mother lives in Central Florida as well, correct? Got to say yes or no.
Yes, sir.
I can see your head, but we're being recorded, so that's why I need a verbal answer. Thank you. Any other family members in Central Florida?
He has a son.
I do have a son.
Okay. Ms. Bowman is saying yes, and you're saying no.
His son lives here.
Okay.
He has a son who's here as well.
Okay. And when you're not in jail, do you have employment? Do you work for a living?
Well, when I'm not in jail, yes, I do, but I do lots of odd jobs and.
Since 1993, what kind of work have you had?
Oh, okay. Since 1993, I've done numerous construction. I owned my own business. I owned a flooring business called GP Floors and More.
Okay.
And I did very well in that. As far as I did a lot of general contracting, that sort of work, tile work.
If I make it a condition of your bond that you not possess any firearms or weapons, are you able to comply with that?
Yes, sir.
Okay.
Yes, sir.
I will, based upon the information I've been provided for today's initial appearance, set bond in the amount of $2,500 with the condition you not possess any weapons or firearms and that you maintain contact with your attorney.
Yes,
Thank
sir.
you, Judge.
Thank you.
Let's go to our Spanish interpreter cases.
Good morning again, Your Honor. This is Theodore Leal, Spanish interpreter, previously sworn.
Buenos dias.
Good morning.
Okay, we put headphones over. Hopefully, Jose Gonzalez Delgado, if you would ask him his name.
José González Delgado.
González Delgado.
Your Honor, may I inquire which category we're in right now?
It was taken, we have 3 Spanish interpreters. What category? So that
Felony.
it's a
He's
sale
in
and delivery
felony,
of
Your Honor.
controlled substance.
It's on page 9.
Thank you.
I've got a case number if that helps. Okay, sir, you've been arrested on a charge of sale or delivery of controlled substance. There is probable cause for your arrest. Bond is set at $1,000. But I have this cover sheet that says bond is $15,000. Okay, so they want $15,000. That's what they said it at. Okay, I'm going to set it, based upon the affidavit, I'm going to set it at $1,000, appoint the office of the public defender. Thank you, sir.
Your Honor, the interpreter couldn't find Mr.
Okay,
Judge, what did you set the bond at?
$1,000. Next, Gilberto Serrano. Tell me your name, please. Oh, no momento. Please tell me your name.
Alberto Serrano.
Alberto Serrano.
Ajá.
Sir, you've been arrested on a charge of fleeing or attempting to elude a law enforcement officer. There is probable cause for that arrest. I'm going to set bond in the amount of $2,000. Having found probable cause, I'm going to revoke your bond in 2021 CF 8403, possession of cocaine, possession of fentanyl, set bond at 0. I'll appoint the Office of the Public Defender in this current fleeing and attempting to elude case. Thank you, sir. Next case I have is Wendy Fernandez.
In Your Honor, in this case, an offer was conveyed. However, I wasn't able to speak with her without a Spanish interpreter, but there is an offer if she wants to resolve it. It's a withhold court costs, credit time served, no return, or pretrial diversion.
Well, it wouldn't necessarily benefit her because she's out on bond for possession of cocaine, and I'm going to revoke that bond. So she's better off resolving everything together, I think.
Yes, Your Honor. I just wanted to make the court
It's
aware.
my experience with the state attorney's office that she get a time served plea on the cocaine or go into a diversion program. So I think that's better if she takes care of it all herself. Ma'am, please tell me, all at once, not all herself, all at once. Please tell me your full name.
Wendy Fernandez Sanchez.
Wendy Fernandez Sanchez.
Sir, ma'am, you're charged with retail theft from Walmart. There is probable cause for your arrest. The bond is set at $250. I'll make it a condition you not return to any Walmart. And as a result of me finding probable cause, I'll revoke your bond in 2021 CF 5886 and set bond at 0. Can't see who the judge is in that case. Division 19. Okay. And I will appoint the Office of the Public Defender in that case. Thank you. Omar Rosario.
No me dio fianza. No entendí.
I did not understand.
Okay. Do you understand that I found probable cause for petty theft from Walmart?
Sí, entendí.
Yes, I understood that.
Because you were out on bond in that felony case for possession of cocaine, and I have found probable cause for a new offense, statutes indicate that I have the authority to revoke your bond on the possession of cocaine case, which is what I have done. So now you're being held on no bond because while you were out on bond for the cocaine charge, you committed a new crime for which I found probable cause. You understand? Okay, thank you. The last Spanish interpreter case I have is Omar Rosario. Please tell me your name.
Omar Rosario.
Omar Rosario.
Sir, you've been arrested on 2 counts of possession of a controlled substance without a prescription. There is probable cause for your arrest. I'm going to reduce the bond in both of these counts to $500 per count and appoint the Office of the Public Defender to represent you. Thank you. And I believe that's our interpreter cases for this morning. Have a nice day.
Thank you, Your Honor.
Thank you. Next case I have is Stephen Albers. Tell me your name, please.
Stephen Albers.
So you've been arrested on a warrant that has already found probable cause. There are 13 different counts. Count 1 is RICO, Racketeering Influence Corrupt Organization. That bond was set at $500,000. Count 2 is conspiracy to commit RICO. That bond was set at $100,000. Count 3 is introduction of contraband into a county detention facility. That bond was set at $5,000. Count 4 is conspiracy to traffic in a controlled substance. That bond is set at $250,000. Count 5 is the same charge, the same bond. Count 6 is the same charge, the same bond. Count 7 is trafficking in illegal drugs, 30 kilograms or more. That bond is $250,000. Count 8 is conspiracy to traffic in a controlled substance. That bond is $250,000. Count 9 is trafficking in illegal drugs, 30 kilograms or more. That bond is $250,000. Count 10 is conspiracy to traffic in a controlled substance, as is count 11. Each of those carry $250,000 bonds. Count 12 is trafficking in illegal drugs, 20 kilograms or more. That bond is $250,000. Count 13, the last count, is unlawful use of a two-way communication device to perpetrate or commit a felony. That bond is $5,000. Your total bonds, according to the math of Judge Tynan, is $2,860,000. I will appoint an attorney to represent you in this case. Thank you, sir. And the condition, if you make the $2 million plus bond, that you not have any contact with your co-defendants. Next, I have Brian Faulkner. Is that you, sir?
Sir.
Good morning. I show that you were arrested on a warrant for burglary of a conveyance and burglary of an occupied dwelling. A judge already found probable cause for that arrest and set bonds in the amount of $3,500 count 1, $5,000 in count 2. I will appoint the Office of the Public Defender to represent you in this case. Thank you, sir. Next case I have is Nikki Davies. Tell me your name, please.
Nikki Davies.
Good morning.
Good morning.
I show that you were arrested on a warrant for violation of probation. Judge O'Kane set no bond on that. I will appoint the Office of the Public Defender to represent you in this case. Thank you. Is this stack next? Oh, there's 3? Okay,
You have 3 cases, Your Honor.
3. Okay.
Hold on.
Hang on a second.
She's got more cases.
Would you bring Ms.
She's got
Davies
more
back?
cases.
I wonder if I missed that. Oh, no, it's a warrant. Okay. Ms. Davies, apparently I overlooked a second case you have, also a violation of probation. And Judge O'Kane issued the warrant in that with no bond as well. The third is a violation of probation, aggravated battery on a pregnant person. And that's got a bond of $3,500. And on the 2 other cases that I did not call initially, I will appoint the Office of the Public Defender to assist you. Thank you, ma'am. Okay. Is this what I'm doing next? Hopefully. Okay, so hopefully Jordan Marr is going to be next. Are you Jordan Marr?
Yes, sir.
Good morning.
Morning, how are you doing?
I am doing fine. You're wearing blue and you have a Band-Aid, so I'm not going to ask how you're doing.
Yeah.
Give me a second here. Looks like you were charged with a violation of probation. And as a result, there is no bond in that case. I will appoint the Office of the Public Defender to represent you. Thank you, sir. The next case I have should be John Debelou.
Yes, sir.
Is it Debelou?
D. Blau, yes.
Blau. Okay.
Good morning, sir.
Spell your last name for me.
It is spelled incorrect on my badge.
Okay, fair enough. Then it's spelled incorrectly here.
Oh, okay.
I get that too. That's why I was asking. Okay.
Okay.
So you were arrested on a charge called battery on a person age 65 years of age or older. There is probable cause for your arrest in this case. I don't have any information about a victim being contacted. Have we heard from the alleged victim in this case?
We had made contact, Your Honor, and informed them of court today.
And did they object to any contact or did they object?
Contact was not discussed with them, Your Honor.
Okay. Then what I'm going to do, sir, is I'm going to set bond in this case in the amount of $1,000. Currently, you have no bond. I'm going to set it at $1,000, and I'm going to have a condition that you have no contact with the victim because we haven't heard from her yet.
Your Honor, could I was actually on the phone with her, and with pretrial was right behind me. And that's my girlfriend of 17 years. She told them specifically, their contact is fine.
And I'm willing to modify that once I hear that, but you just heard what I heard, right?
I understand, yes, sir.
Okay. And I'm willing to modify that. A motion will have to get filed, and she'll have to come in or file a sworn statement. But I'm going to appoint the office of the public defender to assist you in that endeavor. In the meantime, I will set bond in this case
Okay,
with a condition of no contact until I change that, okay?
okay.
Thank you, sir.
Thank you, sir.
Okay. On Mr. Marr's case, do you want to deny the violation of probation so we can expedite this instead of VOP date?
Yes, Your Honor.
Okay.
It's gonna be Division 62, VOP status, January 10th at 9 a.m. and 9 p.m.
Okay. That'll save you about 6 weeks by having you enter a denial of the VOP at this time, okay? So that's what happened. Thank you.
What case was that, Your Honor?
Gordon Marr.
Gordon Marr.
Okay, okay.
That was Mr. Marr. Let's call Andre Larry. Good morning. Tell me your name, please.
Andre Larry, sir.
Sir, you've been charged with battery, domestic violence by strangulation. There is probable cause for your arrest. You currently have no bond. I am going to set bond in this case. Have we heard from the victim?
Oh,
Press the button.
Correct. It's not the alarm, it's the door. Okay. Not so easy, right? Okay. Good morning, ma'am. Can you hear me?
Good morning.
You got to say something so I can.
Good morning.
Okay. Please tell me your name.
Camille.
Your full name, please.
Camille Marie Jones.
Okay. And are you the alleged victim in this case?
Yes.
Okay. I'm about to set bond in this case, but I need to hear from you. Are you concerned about your safety?
No. I want him out.
Okay. So if I indicate he can have contact with you, just no hostile contact, you're comfortable with that?
Yes, I want him out. He didn't. I want
You would
to.
just say yes?
Yes.
Okay. And you're not in fear for your safety, correct?
No.
Thank you very much. Okay.
and he does qualify for PTR, Your Honor.
Okay, then I will release you on pretrial release with the condition you have no hostile contact with her. You understand that? Okay. I will appoint the Office of the Public Defender to assist you in this case. Thank you. Thank you, ma'am. Ainsworth Spence, is that you?
Yes, sir.
Good morning.
How you doing, sir?
I'm doing fine, thank you. I show you're charged with 2 separate offenses, domestic violence, battery by strangulation, and a domestic violence battery. There is probable cause for your arrest in this case. Have we heard from the victim in this case?
No, Your Honor, we were not able to reach them.
Okay. Currently, there's no bond. I'm going to set bond on each of these counts, $1,000 on count one, $150 on count two.
He does qualify for PTR, Your Honor.
It does, okay. I'm going to order pretrial release then on these cases instead of the monetary bond. At this time, I'm going to order no contact with the victim because we haven't heard from her. If you wish to modify that so you can have contact, I will appoint the Office of the Public Defender to assist you. You understand what I said?
Yes. Sir.
Okay, thank you. Next case I have is going to be Richard Barber.
Judge, thank you, sir.
Yes, sir. You Megan Barber?
Not Megan Barber, Maria Luisa Barber. Maria Luisa Barber.
Okay. Raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. And now that you're under oath, tell me your full name and your date of birth, please.
Maria Luisa Barber, September 10th, 1973.
Okay. Good morning, sir. Please tell me your name
Richard Barber,
and your date of birth.
3374.
Okay, you're charged with battery. There is probable cause for your arrest, and I'm about to set bond. Currently, there's no bond set. Are you concerned for your well-being or safety?
I'm not.
If I order a condition of his pretrial release that he not have hostile contact, do you feel comfortable with that?
Yes, sir.
Okay. Sir, I am going to order you released on pretrial release, no monetary obligation, with the condition you have no hostile contact with the victim in this case. Can you follow that condition?
Understood. Yes, sir.
I will appoint the Office of the Public Defender to represent you. Thank you. Thank you, ma'am, for coming.
Thank you.
Next, I have Calamar Boraz Ortiz.
Your Honor, may I be heard as to probable cause on this case?
Well, let me speak first.
Yes.
'Cause I may usurp what you're going to say. Tell me your name, please.
Calamar Ortiz Boras.
Okay.
Yes, ma'am.
So I've reviewed the report. I don't believe there's probable cause for your arrest in this case. Normally, the state could ask for up to 24 hours, which would mean you'd be in jail for another day before they would have an opportunity to try to present probable cause. Or I'll release you on pretrial release today, and we can deal with the case later on at some other time. I'll let you choose your poison. I'll appoint the Office of the Public Defender to assist you in that decision. Do you understand what I said?
Yes.
Okay. And how would you like your client to proceed? You can talk to her in private if you want.
We have a 2-month-old at home, so it'd be
Pardon me?
best. We have a 2-month-old at home, so it'd probably be best for us to do the pretrial.
Okay. And do me a favor then, raise your right hand for me.
Yes, sir. Your Honor.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I swear.
Okay, please tell me your full name.
Fernando Hernandez.
Okay.
So I really think it was it shouldn't have been domestic violence. We were just having a verbal discussion. She put her hand on the back
I
of my
read
neck.
it. I read the report.
And
And there's nothing you can say that's going to make it better.
okay.
Okay.
I'll just be quiet.
And I appreciate you being here. So what would you like me to do?
Yes, Your Honor, if she could be released on PTR at this time.
Okay, then what I'm going to do is I'm going to, state if I find no probable cause, would you ask for 24 hours?
Yes, Your Honor, we did reach out to the officer to request the supplemental report that was mentioned.
Okay, then what I'll do is I will release her on pretrial release with the only condition she has no hostile contact with the alleged victim in this case.
Just hugs and kisses.
And I think I have to find probable cause in order to do that. So with great hesitation and for the accommodation of the parties, I will find probable cause, even though between us, there isn't any, but it gets you out of jail today, okay? You understand?
Yes, sir.
Okay, keep in touch with your attorney. I'm going to appoint the Office of the Public Defender. They can help you get this case dismissed, okay?
All right. Thank you.
Thank you. Thank you for coming.
Thank you, Your Honor. I appreciate it.
Okay, next should be Michael DeHay. Is that you?
Yes, Your Honor.
Morning.
Morning, Your Honor.
I show you're charged with battery. And have we heard from the victim in this case?
We have not, Your Honor. We weren't able
Okay.
to reach them.
And you want to go back to Massachusetts tomorrow?
Yeah, yes, Your Honor.
Okay. There's currently no bond. I'm going to set bond in the amount of $1,000 in this case. And the reason why I would normally set 500, but you don't live here and I want to make sure you deal with this case. So I'm going to set it at $1,000. If you use a bondsman, they'll charge $100 for that. And we'll find probable cause and I'll appoint the office of the public defender to represent you. Do you understand what I said?
Yes, Your Honor.
Okay, thank you. Thank you.
And is
you
he to
making
have
anything
no
else?
contact? Is it no contact, Your Honor?
No, the way I read the report, I'm okay just leaving it the way it is.
Thank you, Your Honor. Nope, you don't have to say.
Next case I have is Jennifer Dole. Right. Tell me your name, please.
Jennifer Dahl.
Okay. You've been arrested on a charge of battery, domestic violence. There's currently no bond in this case. Sir, would you please raise your right hand?
You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, please tell me your full name.
Timothy Nelson Dole.
Okay, you're the alleged victim in this case. I'm about to set bond in this case, which creates a secondary problem. I'll deal with that in a minute. If I have a condition that there be no hostile contact, are you comfortable with that, or would you prefer no contact at all?
No contact, Your Honor.
Okay. I will have a condition. I'll set bond in the amount of $2,000, a condition of no contact. Because I found probable cause for this arrest, I'm going to revoke your bond in case number 2020 MM8281 and set bond at 0 in that case. Because of the new arrest, I will appoint the office of the public defender to assist you. Thank you. Thank you for coming this morning. Next case I have is Shirley Green.
Your Honor, Shirley Green's behavior, but I do believe she has a victim here.
Okay. Is Alvy Green here?
Good morning, sir.
Good morning. Are you Alvy Green?
Yes, I am.
Thank you for coming. This is normally a proceeding where somebody within 24 hours of their arrest gets to see a judge to determine if there was probable cause for arrest and then to set a bond. Apparently, Ms. Green, because of an issue, was not brought this morning. I'm going to reset her for tomorrow morning, and you'll have an opportunity if you want to come tomorrow. We should start up this portion of this at 11 o'clock in the morning, okay?
Okay.
Sorry about the inconvenience.
Is there any paperwork that I can give you in regards to her mental condition, because she has just been released from a psychiatric hospital in Columbus, Ohio, and she has a...
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Tell me your full name and date of birth.
My name is Alvy Lerone Bird Green. I'm born on April 10th, 1975.
Same day as my sister. Okay, and how are you related to Shirley?
She is my wife.
Okay, how long have you been married?
19 years.
So there is probable cause, but I'll make that finding tomorrow. And she does not qualify for pretrial release, but I was going to set bond in the amount of $500. My concern is your safety. Are you concerned for your safety?
I am very concerned for my safety. This woman is very crazy. She's psychotic. She has 8 different mental illnesses.
Okay.
And she has pretty much been in every court in 2 states, Florida and in Ohio.
Okay.
Family court as well.
So
Me included.
you would request no contact?
I request no contact. I do not want to talk to her.
Okay. Thank you for that information. You don't have to come tomorrow if you don't want.
Yeah, I have to go to work tomorrow.
I understand that.
Okay, but I do have the paperwork here.
But
If you would like to
I have your
document it.
testimony under oath, which is why I placed you under oath. And so that's enough information right now. If you want to get that to the prosecutor, are those
Yes, I
copies or are
would.
those your originals?
Mhm.
Those look like your originals. If I were you, I would get those to the prosecutor's office to assist them in their decision on how they're going to prosecute this.
Okay, all right. So
So you don't have to come back tomorrow unless you want to, but you're telling me you want to work. Are those copies?
these are not copies. These
Okay.
are
Make copies of those and get them to the office of the state attorney. Do you have a card where you can contact somebody or some way?
I do not have a card, Your Honor, but let me pull up the case. This is a misdemeanor domestic violence. He can reach out to Travis Tarpey. The email address,
I don't know that he's got a pen.
okay.
I have one copy
Okay.
Okay.
We're going to write down
of
the
previous incident.
We're going to write down the contact information for you for the assistant state attorney on this case, okay?
Yes, sir.
That should help you.
Yes, sir.
Okay. In the meantime, we'll reset this case for tomorrow.
Tomorrow at 11. Okay. Thank you.
No, not yet. Okay. And are you Karen Rutherford?
Yes, sir.
Come on up to the lectern there. Tell me your full name. You've been arrested on a charge of domestic violence battery. I read the police report. There is probable cause for your arrest. Currently, there's no bond, but I'm going to set bond. Have we heard from the victim in this case?
I think you might be outside now.
Okay.
She also qualifies for PTR, Your Honor.
Okay, good morning, sir.
Morning.
I'm going to ask the clerk to place you under oath so we can get your name. Are you Mr. Harris?
Yes.
Okay.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Tell me your full name.
Roosevelt Harris.
Okay, and you're the victim in this case. I'm about to set bond. I'm concerned about anybody's safety in a battery case. Are you concerned about your safety or well-being?
No, I'm not.
So if I issue a condition of no hostile contact, you're comfortable with that?
Yes, sir.
Okay. Anything else you want to tell me?
No, I mean, I think it was just a bad incident. And
Most of these are.
everything's fine.
I see those every day, so
Right.
I'm used to that. Okay, ma'am, well, it looks like you qualify for pretrial release. I'm going to release you on pretrial release with the condition you have no hostile contact with Mr. Harris. Can you follow that condition?
Yes.
Okay, and I will appoint the Office of the Public Defender to represent you. Thank you. Thank you, sir, for coming.
Thank you.
Next, I have Jolene Thornell.
Yes.
Okay, good morning.
Morning.
You've been arrested on a charge of domestic violence battery. There is barely probable cause in this case. I also note that you have 7 prior domestic batteries. Is there a victim in this case present?
I don't believe so, Your Honor.
I don't see
And
any
we did
others
not
here.
make any contact with them.
Okay. What I'm going to do is I'm going to set bond in the amount of $500 in this case with the condition you have no hostile contact, no contact with the victim. I'm willing to modify that once we hear from the victim. But at this point, I haven't heard, so I have to say no contact. I will appoint the Office of the Public Defender to assist you. Thank you, ma'am. And continuing on, the next case I have should be Wesley Barnett. Okay, tell me your full name.
Wesley Devin Barnett.
Okay. So you've been arrested on possession of cannabis greater than 20 grams. There is probable cause for that arrest. So
Can I get this matter resolved today, sir? Because I got an out-of-county warrant that I'm trying to get.
yeah, you also have, let's see, an arrest affidavit for giving a false name as Wesley Barnett, even though you just told me your name is Wesley Barnett, as Antavius Bell.
I've been telling them that's not my name the longest.
And you also have a warrant out of Lake County, right?
Yes, I'm
Okay.
trying to do that.
So this is possession of cannabis greater than 20 grams. It's a felony, so you can't enter a plea. The state has to file charges, and then you can deal with it that way. So I cannot take a plea on that case. I will set bond in the amount of $1,000 in that case and appoint the Office of the Public Defender, having found probable cause. In addition, there's probable cause for giving false name adversely affecting another, and that bond is $1,000. I'll reduce that to $500, and we'll contact Lake County and ask them to come get you on the allegation of violation of probation. On all 3 cases, I will appoint the Office of the Public Defender, and I'm doing that in the Lake County case as well, so that I don't want you languishing here and you being here and not get to Lake County to deal with that, okay?
So if Lake County comes before I bond out, can I just go to Lake County?
Yes.
Okay, thank you.
Okay.
He'll have to.
Judge, what was the bond in the possession of cannabis case?
1,000. 500 on the false name. Yes, and then no bond on the vehicle. Okay, any questions, ladies? Good, thank you.
So I can just contact my lawyer to tell him to try to get me to Lake County?
Exactly.
Okay, thank you.
Okay. Next, Ms. Butcher, is that you? Tell me your full name, please.
Brianna Butcher.
One more time.
Brianna Butcher.
Okay, you've been charged with battery on a law enforcement officer, resisting with violence, and resisting without violence. There is probable cause for your arrest.
Your Honor, may I be heard as to the resisting without violence?
Yes.
I don't believe there's an allegation of this, and I spoke with the state, and she agreed.
Say that one more time.
I spoke with the state about the resisting without violence. We
Yes.
both don't see an allegation of resisting without violence.
right?
So, and she agreed.
Your Honor, the state does agree. It seems that the allegations are that she resisted with violence, which is also charged, making the without violence charge inappropriate.
Well, it says Butcher ignored me and began to incite a fight. So that's where the without is coming. I'll make it a minimal bond, but I think there's probable cause there. So there is probable cause. On count one, I'm going to reduce the bond to $1,000, down from $2,500. Count two is the with violence, that'll be $150. Count three is the without violence, that'll be $100. And I will appoint the Office of the Public Defender to represent you.
Your Honor, did you keep the bond on count one the same?
I reduced it to $1,000.
1,000.
And I will appoint the Office of the Public Defender. Thank you. And I'm only dealing with probable cause at this point as opposed to anything higher than that, which is why.
Yes, Your Honor.
Okay, are you Joseph Dyer?
Yes, sir. Good afternoon, Your Honor. How are you?
Is it good afternoon? Oh, you're depressing me. Good afternoon.
Yes, sir. Good after you.
Okay.
I wanted first by saying I'm going to need a public defender in this case, but I also want to explain that I was invited to this address by Miss Claire. No, I just want to tell the truth. It's okay.
Well, you're being recorded.
Well, it's okay.
And I've got a
But
police-
I'm invited to this address as to my friend Claire, who we were drinking and we were in her room. And of course, we both got naked and we're sitting in her room. And I walk out to use the bathroom and I get a little confused on which room to walk back in. I was the first time there. So I get caught. I seen by the grandmother sees me naked in the hallway in front of the door. So I told her I'm a friend of Claire's. So I go back to Claire and hide in her bathroom and stay there. And all my clothes is in Claire's room, my property, my phone. I got text messages saying that to come over. I don't understand anything about what this is all about. This is not in my character. It's not the type of person I am. I was just invited to the address. We were drinking together.
Said that.
Yeah.
I don't have time to hear it again.
So what do we?
Are you done?
Well, I'm not guilty here.
I didn't say you were guilty.
I just hope they drop this or if I have some kind of a.
I don't think they're going to drop this right now. They may later, but this is only a hearing to determine if there's probable cause. I will find that there's probable cause on count one for resisting without violence when you were ordered to leave the bathroom and you didn't, and I'll set bond at $500 in that. I find no probable cause for count two.
Your Honor, if the state may be heard.
Yes.
The statute says a person commits the offense of voyeurism when he or she, with lewd, lascivious, or indecent intent, secretly observes another person when the other person is located in a dwelling, structure, or conveyance, and such location provides a reasonable expectation of privacy. Here, the victim was in her bedroom in her home, and an unknown naked male entered her bedroom. She woke up to him being in a place where she expected privacy, and she did state to the police officers that she feared that he was going to sexually assault her. The state would argue that there is probable cause for voyeurism.
Okay. I'll find no probable cause for voyeurism in count two. I'll find no probable cause for burglary with an assault or battery. And I will find probable cause, and the accused just confessed in his statement a few minutes ago, for indecent exposure. I'll set bond in that case in the amount of $1,000 with the condition you not return to the address where this occurred, and you have no contact with the 90-year-old alleged victim in this case. And I'll ROR on the counts where I found no probable cause.
Oh, thank you, sir.
And I will appoint the Office of the Public Defender to represent you.
He's out on RR, Your Honor. He has an open case.
I will, based upon finding probable cause in 2021 MM 51 AE, revoke the bonds on counts 1, 2, and 3, battery, petty theft, criminal mischief, and set no bond.
Okay, thank you. Thank you, Your Honor.
Yes, sir. Andrew Ensminger. Is that
Your Honor,
you?
did you appoint the public defender?
Yes. Are you Mr. Ensminger?
Do you have a jail number, Your Honor?
Say that again, please.
Do you have a jail number, inmate number?
Yes, I'm looking for it. Here's a court case number. Yeah. Here we go. 210-28102.
They bonded, Your Honor.
Ah. Okay. You, Mr. Hollinger. Good morning. Come on up to the lectern there.
I'm sorry, Your Honor, which one bonded?
Ensminger. Okay. And this is Mr. Hollinger. You've been arrested on a charge of failure to appear. That warrant already has a bond set in the amount of $5,000. I will appoint the office of the public defender to represent you in this case. Thank you, sir. Next case I have is Osiris Cambon.
Use, Your Honor.
Okay, then I will find probable cause. I'll leave bond set at $30,000 in count one, $300 in count two. And take, pardon me? Yeah, because he refused, I'm finding that he waived his appearance. And I'll make I will make the findings I just found. I'll take no other action. Take no other action. Okay?
Did you appoint the public defender?
I did not.
Okay. Your Honor, I had Gonzalez Delgado in my stack. Did we miss him?
He was already addressed.
They were seen.
Oh, sorry.
Okay. Are you Ernest Lewis?
Sir.
Nice haircut.
No, sir.
Tell me your full name.
Ernest Lewis.
Okay. I show that you were arrested on a charge of destruction of evidence. There is probable cause for that. I'm going to reduce the bond from $1,000 down to $150. Appoint the office of the public defender. You were arrested on alcoholic beverage open container. The bond was $250. I find probable cause. I'll reduce the bond to $150. And you were out on bond in case number 2021 MM1280. I'm not going to revoke the bond on that. I will appoint the office of the public defender to represent you. I reduced the bond. Yes. That's okay. And then I reduced the bond on the second charge.
What did you reduce the bond on the first charge to?
500.
Thank you.
Second 150, and I did not revoke his release.
Yes, Your Honor.
Okay. Are you Mr. Little?
Sir,
Good morning. Tell me your full name.
Captain Little.
Okay, actually, it's good afternoon. You were arrested on a charge of burglary of a conveyance, criminal mischief, and grand theft third degree. There is probable cause for those. Bonds are set at $3,500 count one, $100 count two, $150 count three. I will appoint the office of the public defender to represent you. Thank you, sir. Okay, if we'll have the Assistant State Attorney this morning announce her identity for the record.
Assistant State Attorney Mackenzie Allen.
Thank you. The court reporter needed it.
Oh, yeah, I announced at the beginning too.
Okay. And for the Office of the Public Defender?
Yes, Kaylee Lamphere on behalf of the Public Defender's Office.
Okay. Hopefully Michael Lucchesi is next.
His behavior?
Okay. Then we'll reset this for tomorrow and see if his behavior improves. I have Antoine Luckett. Morning, or good afternoon. Tell me your full name.
Antoine Lee Lackett.
Sir, you've been arrested on a warrant for failure to appear. There is no bond on that case. You also were arrested on resisting an officer without violence and battery. There's probable cause for those. And bond in count one is $500. Bond in count two is $100. I will appoint the office of the public defender to represent you in those as well. Thank you. Next should be Mr. Martin. Are you Mr. Martin?
Yes, sir.
Tell me your full name, please.
Nathan Allen Martin.
Okay, sir, you've been arrested on a couple of warrants here. Let me go over them with you. The first one is a warrant for burglary of a conveyance, grand theft, receiving money from a pawnbroker by false verification. And that warrant's out of Orange County. Bonds were already set. Probable cause was already found. Bond in count one is $2,500. Count two is $1,000. Counts three and four are $1,000 as well. You were also arrested on a warrant for burglary of a conveyance and grand theft. Probable cause is already found. Bonds in both of those cases are $3,500 and $1,000 respectively. I will appoint the Office of the Public Defender to represent you in these cases. Thank you.
On the Facebook, he has a no contact, and the 15407 and no contact.
Okay.
And the 15102, he has a no contact with victim as well.
So I'll order no contact with the victims on the first and third case and no return on the second case. No alcohol and drugs in the third case. Okay, thank you. Are you Miss Mercado?
Yes.
Tell me your full name, please.
Autumn Ashley Mercado.
You've been arrested on a charge of possession of cocaine. There is probable cause for that. Does she qualify for pretrial release?
She does not, Your Honor.
She does not. Okay. I'll set bond. It's set for $1,000. I'll set it at $1,000, and I'll appoint the Office of the Public Defender for you. Somewhat of a moot point because you were also arrested on a warrant, 3 separate failure to appears, and 3 separate no bonds. So you're actually going to be held on no bond as a result of those warrants. I will appoint the Office of the Public Defender in those cases as well. Thank you. Sir, tell me your full name. Sir, you've been arrested on a charge of possession of cocaine, possession of paraphernalia. There is probable cause for your arrest, also for open container. There's probable cause for your arrest on that as well. I am going to set bond on the possession of does he qualify for pretrial release?
He does not, Your Honor.
Okay. Then I'll set bond at $1,000 for the possession of cocaine, $100 for the paraphernalia. And for the alcohol beverages, I'll release you on your own recognizance. I'll appoint the Office of the Public Defender to represent you on both of these cases. Are you Mr. Patterson?
Sir.
Good afternoon. Tell me your full name.
Markel Patterson.
So you've been arrested on a charge of possession of methamphetamine and possession of paraphernalia. There is probable cause for your arrest. I'll set bond of $1,000 in count 1, $100 count 2, because you were out on bond for possession of methylene dioxymethamphetamine in case number 2021 CF 15125. I will revoke that bond and set it at 0 and appoint the Office of the Public Defender in both cases. Thank you. Are you Mr. Pollard?
Sure.
Okay, if you'll step up to the microphone, tell me your full name, please.
My name is James Pollard.
Mr. Pollard, it looks like you were arrested on a warrant on the charge of robbery, and that judge set the bond already at $5,000. You were also arrested on a warrant charged with kidnapping and with robbery with a firearm. That judge found probable cause and issued no bonds on both of the counts. I will appoint the Office of the Public Defender to represent you. You'd like to say something?
Yes, sir, I will. I never did any of that.
Okay.
The robbery with kidnapping, that guy was in somebody else's room. The only thing I was guilty of is him coming to my room and he was buying narcotics, and I had his card. Yeah, the camera ain't show. I never did that. I'm not that kind of person. Kidnap somebody, I didn't do that.
Madam Public Defender, I want you to take your hand off the muting button. Your client is against your advice wanting to tell me things. You don't have the right to excise that from the record. You can advise him, and I'll point you on both cases. I think I already have, but I'll point you on both cases. But he wants to tell me that he's not guilty and why he's not guilty, and he's being recorded.
Yeah, and I know it.
But a judge read one person's version of it and found probable cause. The purpose of our system is to give you that opportunity to present your side of it as well. The purpose of the proceeding today is only for me to tell you what the charges are and to let you know what the bonds were in the case. We don't have the opportunity right now to go ahead and hear both sides and determine if you're guilty or not. That will happen, but it won't happen today. And things you say, since it's being recorded, can't help you because I can't make that decision today. Does that make sense?
Sir.
Okay, thank you, sir. There's conditions? Okay, so there's a condition on the case with the no bond of no contact with co-defendants or the victim or witnesses, no return to the scene, and possess no drugs or alcohol while you're out on bond, assuming a bond is set at this point. There's none, so it's a moot point.
I can't even bond out.
You cannot. The judge said the bond is zero, but I've appointed the Office of the Public Defender, and they can file a motion for bond and have a hearing before that judge.
No, yeah, can I please have that?
She can take care of that.
All right.
She's very competent. Okay. You should take her advice. Okay, next. Are you Mr. Pompey?
Yes, sir.
Okay, tell me your full name, please.
Brian Eugene Pompey.
Sir, you've been arrested on a charge of possession of methylene dioxymethamphetamine and possession of paraphernalia. There is probable cause for that arrest. Bonds were set at $1,000, $100. You're also charged with possession of an open container. There's probable cause for that arrest. I'll release you on your own recognizance on that count. I will appoint the Office of the Public Defender to represent you. Thank you, sir. And are you Mr. Quintana? You're not.
Bonded, Your Honor.
Ah, Shannon Quintana bonded. Precludes me from RORing her. And are you Mr. Sharp? No. What happened to Mr. Sharp?
You have an inmate number?
Yes, I have an inmate number of 210-28104.
Bonded, Your Honor.
Oh, okay. And I would have found no probable cause on one of those counts.
I didn't have that file.
Okay, are you Mr. Stenard?
Yes, sir.
Good morning, good afternoon. Tell me your full name.
Ryan Robert Sinar.
Sir, I show that you were arrested on a couple of warrants here. The first one is for failure to appear. It looks like there's 4 separate counts. That judge set bond of $10,000 in count 1, $300 in counts 2, 3, and 4. And in a second case, there are more failure to appears, and that judge set bond in the amount of $5,000 in count 1, $200 on the remaining 4 failure to appears. I will appoint, I don't know anything about the case or the charges, but I will appoint the Office of the Public Defender to assist you in this case. Thank you, sir. And are you Mr. Thomas?
Yes, sir.
Tell me your full name, please.
That is Kendra Thomas.
Okay. I show you were arrested on a warrant for possession of cocaine with intent to sell within 1,000 feet of a place of worship or business. And that judge, having found probable cause, set bond in the amount of $10,000, count 1, and possession of paraphernalia, count 2. Bond was set at $100. There's also a warrant for the same charge, cocaine, sale or delivery within 1,000 feet of a place of worship or business, and the bond is set at the same $10,000. Lastly, you were arrested for obstructing without violence as probable cause for that arrest. The bond was $500. I'm going to reduce it to $150. I will appoint the Office of the Public Defender on all 3 of these cases. Thank you, Mr. Thomas. Are you Mr. Williams?
Yes, sir.
Tell me your full name, please.
Robert Antonio Williams Jr., sir.
Thank you. Good afternoon, sir. You've been arrested on a charge of arson 2nd degree. A judge has already found probable cause for your arrest and set bond at 0. I will appoint the Office of the Public Defender to represent you in this case. Thank you. And there's a condition. Hang on. I'm told that there's a condition. No contact with the victims, co-defendants, or witnesses, even from jail. No return to the location where this occurred, and possession of weapons or firearms. Did I get it?
Yes.
Okay. And are you, no. Mr. Joseph, is that you?
Yes, sir.
Okay, tell me your full name.
113088.
Looks like you were arrested on a warrant for the charge of petty theft. Bond was already set at $500 in that case. And as a result of that, the bond in case number 2021 CF 9401, charging you with grand theft of a motor vehicle, fleeing and attempting to elude, and driving while license suspended, and reckless driving are revoked, and your bond is set at 0 based upon Judge Bain finding probable cause for the petty theft. Hang on one second. I will appoint the Office of the Public Defender to represent you. We're being recorded. There's nothing you can say that's going to change what I did. What do you want to tell me?
Well, Your Honor, once I find out that I had a warrant for my arrest, I
I turned myself in.
Okay.
You know what I'm saying? So
Yeah.
it's like I had got in contact with law enforcement officers. I got in contact with the bond people, and
Right.
turned myself in. The petty self warrant that's going on. It was a deliberate thing from somebody else because I did not want to be in a relationship with that person. So they deliberately did this right here in order to get my bond revoked. And they told me they were going to do that. And that's why I'm back in jail. I've been honest, I've been going to work, I've been doing everything I need to do, but since I was in here before and they was taking care of me and sending me commissary and stuff, they deliberately did this.
Okay. What you're saying would not be consistent with you being out on bond for stealing allegedly a motor vehicle, fleeing police officers, driving recklessly. And since Judge Bain found probable cause for another crime of violence while you're out on bond for a crime of violence, I'm revoking your bond. Thank you. Next case I have is Mr. Hernandez. What happened to Mr. Hernandez?
You have a booking number for them, Your Honor?
You're gonna make it difficult. Okay, I have 21028-103.
They bonded out.
And how about Justin Jenkins? Want that number?
You have a booking number for them as well?
I do. 210-28092.
Looks like they also bonded, Your Honor.
Makes sense to me. And are you Alexander Johnston?
Yes, sir.
How about that? Three's a charm. Okay. You were arrested on a charge of driving while license suspended or revoked, operating a motorcycle without a license, and a non-moving failure to register a motor vehicle. There is probable cause for your arrest. And bond is 500 in count 1, 100 count 2, 100 count 3. In addition, it looks like your bonds person, Moncrief Bail Bonds, endorsed your bond in 2021 CT 2039, a driving while license suspended charge. So you still have a bond in that case, but you're being held on that $500 bond until you rebond out because Moncrief didn't want to deal with you anymore, apparently. So you know how that works. Next, they did the same thing in 2021 CT 2040. They endorsed the $100 bond in this case, in that case, as well as the $100 bond in 2021 CT 2041. So again, you still have bonds in those cases, but you'll have to hire a different bondsman or give Moncrief more money to bond you out.
Yes, sir, Your Honor.
I will appoint the office of the public defender in the new case that I announced in this matter.
I have a question, Your Honor.
Yes.
I'm actually on here on a VOP too. I haven't received none of my paperwork. I've been in jail 2 weeks now. I was seeing if I could see my recommendation from my probation officer, if you could read that to me, because I have no paperwork or nothing on that.
What case do you don't know the case you're on probation for? Was it a
Your Honor, I
felony?
have the case number here.
Is it a felony or a misdemeanor?
Felony.
A felony. Who's a judge?
It looks like it's you, Your Honor.
Quite a few?
It looks like he has a status hearing on December 8th.
Okay. I'll see you, or a judge, December 8th. That sounds like my case. Is it Division 10?
Yeah, it's you, Your Honor.
Then I'll see you on the anniversary of the assassination of John Lennon,
Thank you, Your Honor. Have a wonderful day.
which is next week. Okay. You're not Yvette Roxanne, are you?
No.
Okay.
That's not-
You have a booking number, Your Honor?
Bonded out, okay?
Do you have the booking number?
Yes. Madam Clerk's gonna help out.
Okay.
10-280-99.
That's because she had lunch and I didn't.
They bonded.
Okay. Are you Robert Thomas?
Yes, sir, Robert Thomas.
Perfect, okay. Looks like you were arrested on a warrant for failure to appear for driving under the influence. That judge set bond in the amount of $3,000. A bondsman will take $300 and then bond you out. I will go ahead and appoint the office of the public defender to represent you.
I gotta get.
Okay, we're gonna give you a pretrial date.
It's gonna be Division 80 pretrial conference, January 27th at 9 a.m. and 9 p.m.
That'll be me.
So you should try to bond out, otherwise you're gonna be in jail for
Okay.
about 6 weeks, okay?
Okay, that's all.
Okay.
Thank you.
Yes, sir. Step up to the microphone. Tell me your full name, please.
James Alexander Wills.
Okay, Mr. Wills, I show that you were arrested on a charge of DUI. Probable cause for that arrest. Bond is set at $1,000. You were out on bond for a DUI in case number 2020 CT 5364. I'll revoke the bond on that and set bond at 0 and appoint the Office of the Public Defender to represent you.
So you guys have to get a bond.
Yeah, I can see the bottom of the stack.
Your Honor, just to clarify, do you have to make findings of probable cause for these ones as well or not?
For which ones?
Like the DUIs and traffic violations?
For this gentleman?
Yeah.
I found probable cause for the DUI.
Oh, I'm sorry, I didn't hear it.
Yes. And the next case should be Richmond Kajust.
You bonded, Your Honor?
Next case I have is Carl Caudell.
He refused?
He refused. Okay, so on that case, I'll find that Mr.
Your Honor,
Caudell.
going back to Mr. Will's case really quick, on that case, the 2020 CT 5364 AO case, he informed me that he doesn't have a public defender. He would like a public defender appointed.
I will do that.
Thank you, Your Honor.
So in the one where I rewrote the bond. So on Carl Caudell, I'll find that he refused to come, so he's absented himself of his own volition. I'll find probable cause and set bond in the amount of $500 and take no other action. Right. Are you Mr. Ferguson?
Yes, sir.
Okay, good morning. Good afternoon, sorry.
Good morning.
You've been arrested on a charge of retail theft. I think this is the beer situation? Yep, the beer situation. From Wawa, there's probable cause for your arrest. Bond is set at $500. I'll
Your
make a
Honor.
special condition you not return to any Wawas while you're out on bond, and I'll appoint the Office of the Public Defender who wants to say something.
Yes, Your Honor. I've spoken with Mr. Ferguson. He did agree to the state's offer of an adjudication, court costs, and credit time served. So he would be entering a no contest plea to this charge today.
Two things. I don't accept no contest pleas. He'll have to admit to being a thief. And I need to hear from the state what kind of priors he has before I agree to time served.
Your Honor, he has 2 prior out-of-state petty theft convictions. However, the records from those are not clear enough fingerprints to be used as JNS's.
Okay.
His 3rd petty theft was nil pros because it was a low-value item, and he had already done 60 days OCJ on it. This would be his 4th petty theft, 3rd conviction.
Okay.
He does have a propensity to steal beer.
Okay.
And that will stop, Your Honor. I did do it. I'm sorry. And I'm going to stop.
How many times did you say that?
Oh, my God. It's hard when you're drinking and being stupid.
Yeah.
You got to slow down.
You can drink and destroy your own liver, that's fine, but it's not fair that you steal from a business that's trying to make money. And
wouldn't.
apparently this isn't the first time, so I'm not going to agree to a time served. If you want to agree to 10 days, I'll give you 10 days with credit for the 2 days you've already served. But I'm not going to do a time served. So if you want to enter a plea of guilty, I'll take that. If not, that's not a problem. I'm not offended.
Thank you.
What do you want to do? Okay, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Put your hand down. Tell me your full name and date of birth, Mr. Ferguson.
Raymond Ferguson,
Date of birth.
12/16/57.
Okay, sure, you're charged with petty theft, a crime that carries up to, is it a secondary misdemeanor, so 60 days?
Yes.
Okay, 60 days and a $500 fine. I understand you wish to plead guilty to the charge and receive an agreed sentence of 10 days in jail and adjudication of guilt. I'll order court cost of prosecution, and I'll reduce that to a judgment, and you resolve your case today. Is that what you want to do?
Yes, sir.
Has anybody forced you or threatened you to get you to enter this plea?
No, sir.
Are you doing this then of your own free will?
Yes.
Mr. Ferguson, can you read, write, and understand the English language?
Yes.
Did you read and understand this one-page plea form?
Yes, sir.
It lists the rights you have and therefore the rights you give up when you enter a plea. And did you understand those rights?
Yes.
I'm going to find that there is a factual basis based upon the arrest affidavit in this case to the charge of petty theft, a second-degree misdemeanor. Do you plead guilty or not guilty?
Guilty.
I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea. I found a factual basis. State anything before I impose sentence.
No, Your Honor.
Mr. Ferguson, anything you wish to say before I impose the agreed sentence?
No, sir.
I will adjudge you to be guilty, sentence you to 10 days in jail with credit for time served of 2 days. What? Hmm? Yeah. 2 days. Credit for 2 days. You've already, wait, hang on. I have to order court costs, cost of prosecution. I'll reduce that to a judgment. Anything else, Madam Clerk? No. Then I got to charge another fee. So I'm not gonna do that. Okay. Thank you, Mr. Ferguson. Stop stealing. Okay. Step on up to the microphone, sir. Tell me your name.
Your Honor, Maldonado Cabre, he refused.
One more time, please.
Maldonado Cabre, Isaac, refused.
You refused. Okay. Hang on 1 second, sir, before I get to your case on Isaac Maldonado then. He refused. I will find that he absented himself, find probable cause for trespass on property after warning, leave bond at $500. Find probable cause for possession of paraphernalia, leave bond at $500, revoke his bond in 2021 MM 3163. Having found probable cause, and revoke his bond in 2021 CF 12779. Having found probable cause, I'll take no other action. Are you Mr. Torres?
Yes, sir.
Okay, good morning, good afternoon. You're charged with trespass on a structure or conveyance. There's probable cause for your arrest. Bond is $250. Does he qualify for pretrial release?
He did not, Your Honor.
Okay, then I'll leave bond at that. I will appoint the office of the public defender.
He is interested in pleading, Your Honor. The offer is a withhold and court costs.
Okay, sir, my understanding you wish to plead guilty to this charge and receive an agreed sentence of a withholding of adjudication, order that you pay court costs, cost of prosecution. Is that what you wish to do?
To what? Do I have to pay the court now? I'm sorry, Your Honor.
That's okay. I want you to understand. Is that what you wish to do?
Yes, Your Honor.
Has anybody forced you or threatened you to get you to enter this plea?
No, Your Honor.
You're doing this of your own free will.
Yes, Your Honor.
As you stand before me now, are you under the influence of any drugs, medication, or alcohol?
No.
You suffer from or ever been diagnosed with any mental illness?
No, just call anxiety.
We all have a little bit, but is that keeping you from understanding what's going on?
No, no.
Fair enough.
No, Your Honor.
How far did you get in school?
2 years college and then 2 years of tech.
So you can read, write, and understand the English language?
Yes, Your Honor.
And did you read and understand the rights you have on this one-page plea form?
Yes, Your Honor.
Have any questions about it?
No.
I will find there's a factual basis based upon the arrest affidavit in this case to the charge of trespass in a structure or conveyance. Do you plead guilty or not guilty?
Oh, guilty, Your Honor.
I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and that I found a factual basis. Anything you want to say before I impose the agreed sentence?
Oh, Your Honor.
I will go ahead and withhold adjudication of guilt, sentence you to 2 days in jail with credit for 2 days that you've already served. I must order that you pay court costs, cost of prosecution. I will not appoint the office of the public defender because it will cost him another $100. And I'll reduce it to a judgment. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, I'll appoint one for you. Do you understand your sentence?
Yes, Your Honor.
Good luck to you.
Thank you.
Okay. Next case I have is Ruben Trinidad. Is that you?
Sure, Your Honor.
Good afternoon.
Good afternoon.
I show you're charged with retail theft, and there is probable cause for your arrest. I'm going to set bond at $500 and order that you not return to any Walmart. I will appoint the office of the public defender to represent you. Thank you.
And Your Honor, before court, it was found that Mr. Trinidad is out on ROR in an open Orange County case. It's for 2021 CT 002985AO for a driving while license suspended.
I'll take no action on that. Thank you. Okay, next I have Anthony Williams. You, Mr. Williams? Yes?
You have the case number?
Matt, would you repeat that case number for the,
Sure. It's 2021 CT 002985 AO.
2985? Yeah, Torres.
That's
No,
for the
not
Trinidad. Trinidad Rodriguez, Ruben.
Right. I don't think we knew we had it. I don't think there's an order for it. If I would have had the sheet, I would have addressed it. Torres is the plea. Good? Yes. Okay. And you're Anthony Williams, yes or no?
Sir.
Thank you. I show you're charged with resisting without violence and loitering or prowling. There's probable cause for your arrest. Does he qualify for release?
No, Your Honor, he does not.
I'll leave bonds at 500 and 100. Appoint the office of the public defender to represent you. Thank you, sir.
Your Honor, in this case, he does have an offer in both cases. If he wishes to plead guilty, it would be an adjudication on both counts, court costs and credit time served. I've spoken with him, and that's what he wishes to do. I just don't have a plea form.
Okay. So it's a withhold and time served?
Adjudication
Adjudication.
and time served.
Is that right, State?
Yes, Your Honor.
Okay, sir, your attorney tells me you wish to, actually, do you wish to plead guilty to resisting without violence, a first-degree misdemeanor punishable by up to a year in jail, $1,000 fine, and loitering or prowling, I think that's a second-degree misdemeanor. Is it a first? It's been a long time.
Let me look real quick, Your Honor.
The loitering should be a second degree. I believe.
Second? It's probably been 38 years since I looked at an LMP.
Yes, Your Honor. Second degree for the loitering, first degree for the resisting without violence.
And so that the loitering carries up to 60 days in jail, $500 fine, that you wish to enter a plea of guilty and resolve this case with an agreed sentence that I am willing to go along with. Is that your understanding? Has anybody forced you or threatened you to get you to enter this plea?
Sir.
You're doing this of your own free will?
Sir.
As you stand before me now, are you under the influence of any drugs, medication, or alcohol?
Nope.
Do you suffer from or ever been diagnosed with any mental illness? Do you suffer from or have you ever been diagnosed with any mental illness?
No.
Okay, I will find there's a factual basis based upon the arrest affidavit in this case. Did you read and understand the plea form that lists the rights you have and the rights you give up when you enter a plea?
Mm-hmm.
Do you have any questions about those rights? To the charge of resisting without violence and loitering or prowling, do you plead guilty or not guilty?
Not guilty.
Not guilty. Okay, then I'll leave this case set and I will appoint the office of the public defender to represent you. Thank you. The next case I have is Danielle Aguirre. Correct. Tell me your name, please. Okay, good afternoon. I show that you're charged with neglect of a child without great bodily harm. There's probable cause for your arrest. And I thought this was an emergency warrant I signed last night.
Your Honor, this is Danielle Aguirre, right?
Yes.
Okay.
Did I sign it last night?
I don't think it says, Your Honor.
It says no bond, so I might have said no bond until initial appearance. So I'm going to set bond in the amount of $2,500. Right now it's set for no bond. I'm going to set it to $2,500. And I will find probable cause and a condition that you not have any contact with the child in this case until further order of the court. Apparently DCF is involved. Is that your understanding? Okay. I will appoint the office of the public defender to assist you. Thank you. The child. Who is the victim? Okay, continuing on. Tell me your name, please.
Evan Burchin.
Okay, good afternoon. I show that you were arrested on a warrant out of Seminole County and bond is set at 0. It indicates a violation of probation for methamphetamine. I don't know what the allegation is or if it's a new law violation. Let's see, there's another out-of-county warrant. There's 2 of them, and they both have no bond. You're out on bond in a felony case here, 2020 CF 11648, but I don't know if the violation of probation predated it. So I don't have the authority to revoke the bond on the 2020 CF case. So I won't revoke the bond on that, but you do have no bond on the Seminole County cases, and we'll contact them and ask them to come get you, okay? Okay, tell me your name, please.
Denarius Denard, Your Honor.
Okay, good afternoon, Mr. Denard.
Good afternoon.
I show you were arrested on an out-of-county warrant.
I turn myself in, sir.
Okay. Bond has already been set at $500. There's also another warrant, and that bond is $500 as well. You were out on bond on a felony case here in Orange County. I'm not going to revoke the bond on that because I don't know when the out-of-county case occurred. And so I'm not going to revoke the bond on your Orange County case. So you have bond, bless you. You have bond on the 2 warrant cases at $500 apiece. Does that make sense?
Yes, may I speak?
You can, you're being recorded, and there's nothing you can say that's going to change what I did, but you can speak. What do you want to say?
It's fine.
Okay, thank you. Next case is it Casey Johnson? Are you Casey? Yes, sir. Good afternoon. I show you were arrested on a warrant out of Leon County, and the bond is set at 0, and another warrant also out of Leon County, and the bond is 0. I will go ahead and they're both grand theft. I wonder if it's the same case. Oh, okay. So they're duplicates.
Yeah.
Okay. So here's a grand theft motor vehicle. That bond is 0. Here's a grand theft, also out of Leon County, and that bond is $5,000. Then there's use possession of another identification or ID. That bond is $5,000 as well. And the last one is, that's a duplicate. And that's it. I just have 3. I missed one. Hang on, Madam Clerk says I missed one.
There should be one more $5,000 bond one.
Okay, so there's one more with the $5,000 bond as well. Okay. So you have some bonds and some, but you have none in the others. So the end result is you have no bond. We'll contact Tallahassee and ask them to come and get you, okay? Thank you, ma'am. You may. They don't. That's a good question. They don't. They don't? No. Anytime. No, I'm not. Okay. And are you Franz Pierre?
No, sir.
What happened to Franz Pierre?
You have a number?
Yes, 210-28101.
They bonded.
Okay. Are you Anthony Reina?
Yes, sir.
Okay, good afternoon.
Good afternoon, Your Honor.
I show that you were arrested for a warrant out of Osceola County, and the bond is set at 0. Another warrant out of Osceola County, unless it's the same one. Yeah, it appears to be the same one. So there's only one set at 0. You were out on bond on a 2021 case for grand theft 3rd degree. I don't know when the allegations of violation of probation took place, so I'm not going to revoke your bond in the Orange County case. Do you understand? And I'll take no other action. Thank you. Next case I have is George Maxwell.
Is it medical?
Okay, we'll set this for tomorrow and see if Mr. Maxwell can come join us. The next case I have is Sean Pericles.
Good afternoon, Your Honor. My name is Sean Pericles.
Good afternoon, sir. I show that you're charged with violation of probation,
Yes, sir.
and the bond is set at 0. There's another, there's a possession of less than 20 grams of cannabis. There's probable cause. That bond is set at 500. So the only new arrest I can see is the possession of cannabis. You're out on bond for burglary of a conveyance in 2021 CF 3710. Because the allegation of the new charge is only possession of misdemeanor marijuana, I'm not going to revoke your bond on the burglary of a conveyance charge.
Yes, sir.
I will appoint the office of the public defender on the violation of probation and the marijuana case.
All right, sir. Thank you.
Okay, you're welcome. Continuing on. Are you Willie Flores?
God bless you, Your Honor.
Okay.
God bless you.
I show that you're charged with disorderly conduct. There is probable cause for your arrest.
Yes, sir.
How would Mr. Flores like to proceed?
Context.
Your Honor, I didn't get an offer from the state in these cases.
State, can he have a withhold and court and time served?
Yes, Your Honor.
Okay. Would you like to plead guilty to disorderly conduct and receive a withhold and time served? Yes? Has anybody forced you or threatened you?
No, sir. No, sir.
You're doing this of your own free will?
Yes, sir.
Are you under the influence now of any drugs,
No, sir.
medication, or alcohol?
No, sir.
You suffer from or ever been diagnosed with any mental illness?
No, sir.
And
Thank you, Your Honor.
and I'm asking the attorney next to you to assist me and have you read a plea form that lists the rights you have and the rights you give up when you enter a plea. After you've read it, if you'll sign that, you read, write, and understand the English language.
Yes, sir.
Okay, if you'll take a look at that. In the meantime, I will find probable cause for disorderly conduct, a violation of a city ordinance, 4306, 43.06. Okay, you've signed that. Do you understand those rights?
Sir, Your Honor.
Then to the charge of disorderly conduct, do you plead guilty?
Yes, sir. Yes, sir.
I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and that I found a factual basis. Anything you want to say before I impose the agreed sentence?
Merry Christmas.
Pardon me?
Merry Christmas.
Thank you, sir. I will go ahead and withhold adjudication of guilt, sentence you to time served, order that you pay court costs of prosecution, reduce that to a judgment. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, I'll appoint one for you. Good luck.
Thank you. God bless you.
Thank you. Brianna Gwynn.
You have a booking number for them, Your Honor?
I do. 210281110.
They bonded.
Raymond Anthony Lamar.
His mental health.
We'll reset this for tomorrow in hopes that he'll get his mental health returned to him. Gianna Malave.
Bonded.
That's a shame. I was going to ask if her mother was somebody I know, but I won't get to do that. Next case I have is Juliana Weber.
Also bonded.
Then we will be in recess until tomorrow morning. It is now 1:15-ish. Thank you all very much. How many cases did you deal with today?